ready.
Okay. Hi there. When most people think about estate planning, they think about what happens after they die. But here's something I want you to really hear. Statistically, most of you are far more likely to become incapacitated at some point in your life, prior to your demise, than you are to die unexpectedly. That's the scenario that almost no one plans for. I'm James Anderson with Anderson Law Firm, and today I want to talk about the estate plan nobody talks about, and that's incapacity planning. What do I mean by incapacity? I'm talking about stroke, a car accident, early onset dementia, a surgical complication, anything that leaves you alive but unable to make your own financial or medical decisions. Here's what happens if you don't have a plan. Your spouse, your kids, your parents, they have to go to court and petition for a conservatorship or a guardianship. That means a judge, a stranger, decides who manages your money and makes your medical decisions. It takes months. It costs thousands, and it's public record. It adds insult to injury, as we tell our clients all the time. Spouses and adult children fighting in court over who gets to make decisions for mom and dad, groveling before the probate court for permission to take care of their loved one, is heartbreaking and is also 100% preventable. There are three documents, that form your incapacity plan. Let me walk you through each one. One, your durable power of attorney. That is your bedrock incapacity planning foundation. Okay? That's your financial voice. When you sign a power of attorney, you're naming someone, we call them an agent or an attorney in fact, who can step in and handle your finances if you can't. Pay your mortgage, manage your investments, file your taxes, keep the lights on, make gifts for you, tithe. And here's something that's really important. A well-drafted power of attorney can include gift-giving powers that can be critical for Medicaid planning down the road. There'll be a video on that at some future date. The key word here is durable. That means this document survives your incapacity. Document number 2, your healthcare power of attorney. This is your medical voice. You're naming someone to make medical decisions for you when you can't speak for yourself. End-of-life care, surgical decisions, treatment plans, all of it. In South Carolina, we use a state statutory form, and getting the details right does matter. So if you're at the doctor and they give you a hard time and ask you if you have an advance directive or a living will or a power of attorney, that's the document that they're referring to. Okay? Now, on to the third document. That is a HIPAA authorization. So that's also medical related, and this is specifically for your confidential medical records. Federal privacy law means your doctors can't talk to your family without your written authorization. I don't care if you've been married 40 years. Without a HIPAA authorization, that hospital cannot share your medical information with your spouse or your kids. I promise you, in a crisis, that's the least thing your family needs to be dealing with. Here's the bottom line. Your incapacity plan is just as important as the after you die stuff. Maybe more so because you might actually be around to experience the consequences of not having one. Here at Anderson Law Firm, these documents are part of every estate plan that we produce. We don't sell them a la carte because they're not optional, they're essential. If you don't have these documents in place, or if they're more than a few years old, particularly if they're more than about 5 or 6 years old, it's time to update them. Give us a visit at sclegacylaw.com or call us here at the office at 864-228-7808, and we'll see that you get this taken care of. Thanks for watching.